screen, Matthew, right?
Yep.
Wonderful. So, uh, hello everyone. I have Matthew today to discuss a very important thing which affected many, many members within our union, but also many public servants and many Canadians. My name is J4EIM. I'm showing you the website, my official website as a candidate for PIPSC vice president. I was running for this position last year. And why I'm running for this position? Because I need to speak on behalf of all those members who have been badly affected by the vaccination mandate. And this is one of my priorities here. Transparency is particularly related to vaccination mandates, how decisions were made, and why the union does not support the members who are filing the grievance related to those mandates. And on my website, you will be able to see I have developed a page called Self-Representation 101. And in here, we just decided we will be using use cases from different members, discussing their stories and why the union didn't want to support the grievance. And they can still file the grievance and they can move on and defend themselves. We already have successful cases when members defend themselves without a union. But essentially, the union has made it very clear. I do not recommend filing a grievance on anything related to vaccination mandate policy, on your leave without pay, or religious exemption. Why? Because it's not in line with the union position. And here I have, as also on my electoral platform, this very important statement that the union has decided to support. They decided to support vaccination mandate, and for that reason, they do not recommend filing a grievance. So we're doing it ourselves. And I have started a series of tutorials or guidelines for anyone who is interested to learn more about the issue and how unjustly, how many members were denied not only the salary, but also the employment insurance money, which they paid for many, many years. And they were not able to get a cent out of employment insurance when they were put on leave without pay for administrative reasons. And here I have example. I have example of the decision of the response from the management related to one of the grievances. The grievance said that I think they agreed decision to classify as code M for misconduct on my record of employment when they put on leave without pay. And the employer replied, it's right in here. In fact, I will make it bold here. They said there is no mention of misconduct on your record of employment. And this was the correct code M, which was used regarding your situation. And I'm confident it was administrative measure based on your vaccination status, not a disciplinary one, because code M stands for misconduct, and it was treated by employment insurance as misconduct, as if you stole something, as if you've done some other bad things. You misbehaved, you are disciplined, and that's why you are not receiving employment insurance. Okay, so we have multiple complaints from members like that. The union doesn't want to do anything related to vaccination mandates or the problems the members have experienced themselves. So now that's why we started this series, Self-Representation 101. And in here, you will see one of the articles was specifically fighting employment insurance denial for bodily autonomy or for consent. and launch of a new Substack, new portal called Justice for Employment Insurance Misconduct. And when you click there, you will get to this portal, which is set up by Matthew, my guest today. So Matthew, I'm giving the floor to you. We will have a series of presentations. It's a rather rich in terms of information subject, because the machinery has been developed well in advance and it's very sophisticated. It didn't allow a choice for any agency to do anything but to write to leave without pay as misconduct, M, which was treated as you are a bad guy, you are a criminal essentially, you will not get anything from employment insurance. That's how I understood it. And again, I'm here just trying to vocalize concerns of many members in a hope that union will listen, employer will also listen and then understand, and eventually we'll get justice. We'll get some justice done for all those cases. Matthew, the floor is yours. And you can start sharing your screen if you wish to.
It says it's disabled. I think I need permission to share.
So, are you able to share the screen right now?
No, it says you have to check the security tab at the bottom. Screen share is disabled.
How about if I open your presentation?
Oh, no, it's good now. Whatever you changed, fix it. We're good.
Matthew has sent me his presentation.
There, can you see it on the screen?
Yes, I do see it on the screen. Wonderful.
Okay, wonderful. Thank you. So I do want to thank you, Dimitri, for giving us this opportunity here. I want to discuss, we all know that there was a serious problem that happened during the pandemic, and especially with EI. There were hundreds of thousands of lives that were destroyed because of this issue. What I want to do is try and explain the how and the why so that everyone can understand what the problem was and why they had to respond the way they did to destroy so many lives. And once we understand the how and the why, then it's straightforward to figure out a response. So I have a presentation here that we'll look at in pieces. So the first one, who are we? So I want to outline this project here, and I'll keep it very high level. During the pandemic, the lives and careers of many Canadians were crushed by this label of EI misconduct. It was used in hundreds of thousands of cases. And that actually is a criminal code offense. We'll get into that later. But putting the wrong code on a record of employment actually violates Section 398 of the criminal code. So our goal is to explain the how and the why. And then we invite you to join us on a campaign. We have an opportunity here. Unlike many EI cases that I was reading over, many cases try to find an error in their specific case. And I saw how many people were being abused and how many people were losing. So we decided to take a risk and do something different. We actually challenged the lawfulness of the entire EI process itself. And that led to a long journey of investigating how is EI supposed to work, and then what they did to respond. The only thing we're looking for, if this is something that resonates with you, or that you find important, or if you know people in your lives that were injured by this, we're starting a campaign to use public interest letters. The only thing we ask is we have some pre-written letters to express your concern. So you can read it over, change it if you want, and send it to the courts and to the Attorney General and to the various people involved in this decision-making process, asking them to do the right thing and to encourage the judges that the public actually is watching this and that we support you. And we may file a parliamentary petition as well, depending on how things go. So who are we? This is for a close family member of mine. His name is DA. DA versus Canada is the case. He worked at Purelator for 30 years. I'm going to avoid talking about Purelator because things are being tested in court. This entire presentation is really for education purposes until such time as we have a full decision from the courts. So after losing his 30-year career, he struggled to support his family with part-time low-paying jobs for the next 3 years. And like many of us, this caused health problems, it caused financial problems, which lead to stress in the family. He did lose his family home to the bank. And thankfully this year, he actually did find another career job. And all of our spare time has been spent in the last 2.5 years investigating this, putting the information together so we can raise public awareness so that all Canadians can fight to obtain justice for what happened. Just a little bit about me. I've held different jobs in various fields in the past 25 years, everything from call centers to working in charities. Spent some time in IT, technical, and security roles. I've also had to do landscaping, manual labor. For my education, I was actually 1 semester short of a master's degree in cybersecurity, but then the pandemic happened. And that is my goal once this whole situation is resolved, is to go back and get my master's so I can go back to working in the field. So I was asked to help in mid-2022 to help file for EI, and I agreed. And I had no idea what we were going to experience. Once we uncovered what was actually happening, that there was an engineering of processes that spanned multiple government agencies to coerce decision makers to break the law by denying people EI. Once I realized what it was, we couldn't stop. So we are in this challenge until the very end. So I'm gonna, because everyone with IVIM is already familiar with the pandemic, Dimitri's done a really good job of explaining a lot of the science and medical stuff. We're not going to talk about that in this. We're going to focus strictly on the EI. I just wanted to raise 3 quick points about something that was new during this pandemic. For the first time, we actually shut down the country, the whole world actually, and I'll use their terms, to prevent the spread of a deadly virus. And their chosen method was to quarantine healthy people. Right? Never in history have we quarantined healthy people to stop a pandemic. And of course, those lockdowns caused huge supply chain issues, huge economic problems. So in order to prevent economic collapse, they had to make it safe for people to go back to work. So their choice was to mandate experimental injections. That was new. And also, I think was new is, for the first time, public health agencies and the media corporations joined together for a coordinated nonstop information campaign to promote a particular interpretation and medical mandates countrywide. As I go through this, I'm going to highlight big ideas. What are the main takeaways to keep through this presentation? This is one of the important ones. What happened? So here are the 3 premises of what happened in this EI pipeline. The first one, with regards to employers. Employers granted themselves the right to break the law and contracts just by issuing a policy saying they were going to do it. That is unprecedented. Employers granted themselves the right to break the law just by publishing a policy saying they were going to do it. And then when people pushed back, many, I won't say all, but many companies issued falsified records of employment to justify it. And again, that could be a criminal code offense. Another way to word this is policy over statute, that for the first time, policies have more weight than laws of parliament. So what did the governments do? They use state action to incentivize or pressure private companies to do this. We are protected, right, by our charter rights and the Bill of Rights. There are many things the government cannot do directly, but if they use money and other incentives to incentivize companies to do it, then they can wash their hands of it and say, look, it wasn't our fault, right? And then to compound that, anytime someone challenged it, they just accepted the absurd statement from the employer that, hey, our policy permitted it. So they upheld that. And then, of course, you have adjudicators, the EI decision makers. They refuse to address this injustice. Anytime someone raised the point about why are you breaking the law? Why are you using policies that coerce people to break the law? That includes changing tests that are defined by law. That includes abusing the processes of the court, and many other things we're going to cover. They always argue jurisdiction. It's not in our authority to examine whether or not your employer broke the law. And of course, as we'll see from the EI Act, that is explicitly required. Since 1993, one of the primary reason for determining whether or not to disentitle someone is whether or not their employer acted contrary to law. And there are many cases prior to 2020 where that decision was made. But again, because of an emergency pandemic, for the first time, decision makers were coerced into saying, no, we're not going to look into that, saying it's not within our power. We are going to make this slide deck available to everyone. You'll see we have, as we go through this, many references. For the sake of time, we won't click through them. This will be made available to you so everyone can actually walk through this on their own. So how it happened. As part of any federal judicial review, we have to ask questions of the court. We have 12. I'm just going to quickly read through some of them, and then we'll expand on them as we go through the presentation. So here's a question. Can corporate policy override contracts and provincial and federal law? And I think we would all know prior to the pandemic, that was not a controversial question. Question number 5, when policies do break the laws and contracts, are they legally active? So for example, if an employer had productivity issues and they issued a policy saying every employee must work 24-hour straight shifts with no breaks, is that active? Just because it's in policy, does that stand? And if someone says, I'm willing to work 60-hour weeks, I want some overtime for Christmas to buy gifts for my family, but I'm not working 24-hour straight shifts, and then they're fired for not complying with the policy, what happens? Number 6, when we arrive in that situation, is it permissible for EI decision makers to say, we're not going to consider your contracts. We're not to consider historical common law. We're not going to consider what the EI Act says. It's outside of our scope of authority. Never mind that we did it for decades. Another one is, can tribunals violate home statutes by citing case law? In other words, the EI Act is required. It is the standard by which decision makers make their decision. Can they find a paragraph in a federal court case somewhere, pull it out of context, and use that to justify breaking the EI Act? I think that's an important question. And as we'll see, this happened en masse. And then another one, can decision makers use undisclosed and internal information in their decisions? One of the most important factors that happened is a secret memo was issued that was not available to the public, and it's actually not available to the courts, that changed how Service Canada and EI Commission decision makers adjudicated cases. And of course, that was not disclosed to the public, so even the courts are not aware that this document exists. Is that okay? And the Supreme Court has already said no, that is not acceptable. So I'll briefly look at the root cause. And if you have any questions, please let me know.
Yeah, if you can talk just slightly closer to the laptop, maybe it will be slightly louder. But it is good. It's good. Very good.
Okay. Oh, I see what you're saying. Yep. So how this played out was a story that took a lot of time to uncover. We'll look at the scope of the problem later, but it took a lot of work to pull off what we're going to see is a massive scandal. What ended up happening is that processes that are defined by law were engineered and changed across multiple agencies. Just like we were coerced, and we would say it's not fair for you to make a policy that coerces us to do something. The same thing happened inside the EI adjudication agencies, where policies were crafted that coerced or at least perversely incentivized the decision makers to deny EI cases. And in some cases, there was the threat of their job on the line too. There's also a diffusion of responsibility. Because they engineered processes to span multiple government agencies, it broke out the unlawful actions across many people. So you can't point to a single person who touched your case and say, hey, you broke the law. Because ultimately, it was little pieces that were put together and pushed down across agencies to pull this off. So the process engineers, I think, is really what we need to really start thinking about here. Another problem is that there is no real understanding of the law. The tribunal on their website advertises the fact that 2/3 of the EI tribunal members have no legal training. The only thing they get is what they are taught in a comprehensive training course when they start. And the same thing happens for Service Canada. Service Canada went on a hiring spree around the mandate time, and they hired a lot of new employees who also had no understanding of the law. So if the only thing you know is what you're taught in training, are you going to expect that you are being taught to break the law? If you don't think that's possible, then we have to, is it really the fault of the EI decision makers that this happened? And as we'll repeat, this big idea happens over and over. Policy trumps the law. It wasn't just at the employer. All across the pandemic, not just in EI, but across the pandemic as a whole, something new happened. And that is individuals granted themselves the right to break the law simply by publishing a policy saying they were going to do it. Another issue is the case management tool that is used by the tribunal. It's called J4EIM, and it has a feature called decision templates, whereby chunks of paragraphs are pre-written that already have decisions and footnotes, like case law, built into it. So you can scroll through a list and you can put a template into your decision, and you can put many different blocks of these templates into your decision, which is essentially it's reverse engineering the case. Because if you have a template, I'll use contracts, for example. There's lots of cases where the employer cited the contract and said, hey, you violated your contract, therefore you have no EI. But there are also many cases where employees said, hey, wait a second, the employer is violating my contract. So they had pre-written decision templates saying, yeah, we're not allowed to look at employment contracts. It's outside of our authority. So they can pick the paragraph, they're pre-written. They can pick the pieces and stick them together that allows them to engineer the outcome they are looking for. And we have evidence that decision makers at the tribunal would, in some cases, allow, and other cases, they would deny the use of contracts. In multiple cases, they were handling at the same time, which is a huge fairness problem. So just a quick high level, what were the different ways the processes were engineered? Service Canada issued a secret memo under the DESDA Act, which is the Department of Employment and Social Development Canada. There is, I think it's section 24. It allows the cabinet minister, so the Minister of Employment, to set policy agendas that are pushed down to the different agencies. So they have no force of law. They're just, what direction are we heading through policy agendas? They issued a policy agenda memo called VE Memo 2021 that was not available to the public. And it changed legal tests. It changed the definitions of legal terms that are already defined. It changed the processes that are to be followed. It changed what it means to fact find. And it forced these employees down on Service Canada employees, and they were told, if you don't follow this new set of policies, your case is going to be escalated to management. And a really important thing to note is this policy only applied to employees who were being accused of mandate misconduct. So this policy didn't apply to everyone. It only applied to a specific group of claimants, those who did not comply with a mandatory immunization policy. Another one, I would also encourage people who were affected by this. We're going to provide a lot of details that explain. We encourage everyone to look at their own case to see if these happened to you. I can only prove it happened in my paperwork, but the statistics indicate that these errors happened in hundreds of thousands of cases. And it would be really nice to be able to gather together a list of people saying, hey, me too, this also happened to me. So the EI Commission changed facts in our case, which is potentially a sanctionable offense, right? If you're a lawyer and you're arguing something before a court, and then halfway through the proceeding, you change a fact and argue the exact opposite. So you knowingly change a settled fact in the case. That could be a sanctionable event, and that did happen in our situation. Of course, inapplicable case law was cited. Cherry picking is common, right? There's thousands of EI cases, so you find a paragraph that says something that supports your position, you pull it out and use it. And of course, if you read the whole case, it doesn't say what it says, but that small selection of paragraph makes it appear like it. They also invented a new test for misconduct that had two logical fallacies in it. And of course, under Vavilov, which is the Supreme Court binding case on how to deal with tribunal decisions, it's clear that if you have logical fallacies in your decision, it can be deemed unreasonable. They also engineered an abusive process. So processes are usually defined by statute, and when they're not explicitly defined by statute, generally the case law explains how it works. When you make decisions or pleadings or somehow interact with the case in order to avoid a required process or to inject something that is not there into the process, that can be abusive process, which, like changing facts, can be a sanctionable issue. And that also happened. It happened in thousands of cases at the tribunal, hundreds of thousands across the board. They bypassed Vavilov in many different ways. And of course, all of these things were pushed into templates, which just systematizes the errors. Which, again, we need to focus on who are the process engineers. If we hire decision makers for EI who don't have legal training and then give them tools that they click through that already have predetermined outcomes built into the building blocks, and they just fill in the blanks between the blocks, Supreme Court would say that is not a fair process. And we're going to highlight how that happened over and over and over again. I just want to briefly touch on the impact. This is another big idea that we need to think about here. Between October of 2020 and May of 2023, we pulled, that's about 2.5 years, we pulled a collaboration of stats. This is roughly the vaccination timeline. Right? Vaccines came out in December, but they first started in trials in November of 2020, and the mandates were dropped by June across the country of 2023. So in that time frame, there were 10.4 million applications for EI, and there were 2.6 million denials, which means 25% of the people who applied were denied. I went back and looked at the 3-year block before it, so 2017, 18, and 19, for a benchmark before the pandemic. And in that case, only 15% of cases were denied, which means there was an increase of 65% of people being told no. For these statistics, for our benchmark, I pulled out, can you see my mouse?
Yes, yes, very
okay.
well.
So I created some charts here, and I have a benchmark for EI, and this is just the tribunal. So this does not include all the Service Canada EI commissions, because statistics show about 98% of people do not fight in the tribunal. Once Service Canada says no and the EI Commission says no, they go away. So this only counts people who continue to push and fight for justice. So in 2019, there were 988 cases of EI. Then in the first 2 years of the pandemic, when we locked everything down, there was an average of 650 EI cases per year. So there's a significant drop because people were on CERB and people were sitting at home on lockdowns and things like that. The mandates came in at the end of 2021, and we see an explosion of cases where there's now an average of 1,400 cases per year at the tribunal. And a really important thing to look at when you break it down by reason, what are the standard cases versus mandate misconduct? You can see in 2023, 41.5% of people who appealed their case at the tribunal were mandate misconduct cases for vaccine mandates. So we are not a fringe minority with unacceptable views. During the pandemic, more than 1/3 of all EI cases were based on not complying with the mandates. And you can look at the numbers here for success. So generally speaking, 20% of people who apply to the tribunal are given EI. For standard cases, it's actually 25%. When you look at mandate misconduct cases, it's less than 6%. So something changed in the process between standard cases and mandate misconduct cases that resulted in EI being denied more than 4 times as often. So here's a stat just to keep in mind. The pandemic versus the bench line before, there was more than 1 million denials that took place. And of that, over 1/3 of them were people who were accused of misconduct for not complying with vaccine mandates in the workplace. So what is their solution? Right, they have a big problem. How do they solve it? So we'll just provide a high-level framework for how this works, and then we will walk through the individual details. Due to the pandemic, new EI processes were engineered across multiple federal agencies. Here's a big idea. These new processes compelled EI decision makers to break laws, specifically the EI Act and the DESDA Act, by denying benefits to claimants who were qualified by law. These new processes that only applied to mandate misconduct cases compelled EI decision makers to break the EI Act by denying benefits to someone who the EI Act clearly says should be given EI. How did they do it? Statutory requirements, tests, and definitions were overridden by secret memos and decision templates. These templates miscited case law and abused processes, and these were shoved into pre-written decision templates. They were already pre-written, and they used a modified misconduct test that contained 2 logical fallacies. Hundreds of thousands of claimants were denied. We've done the math 4 different ways. No matter how you slice it, it's between $11 to $13 billion of benefits. Now, if you look at the EI operating budget, which they publish a report in Parliament every year, there's only between $22 and $26 million in EI operating account. So if they had paid out EI to everyone who legally qualified for it during the pandemic, they would have collapsed EI. They would have had to pay out more than 50% of the entire EI operating account to these people on mandate misconduct, which is why they mathematically would collapse the EI program, and they're going to be stuck having to justify it. So they had to find a way.
Matthew, just 3 minutes left for this session, and then we'll have another session.
Okay, we'll just finish this slide then. We're basically done here. So again, that's a $13 billion liability. One last thing, censorship. I have here a screenshot of an event that happened on our docket in our case. It says, notice of motion contained on behalf of the applicant for a confidentiality order. Now, we are pro se, we are self-represented. There is no on our behalf. We don't know who did this, but somehow a motion was filed on our behalf, which is supposed to be signed by us, requesting that the entire case and all evidence be censored under a confidentiality order. We didn't do this. We don't know who did it, but that just gives you an idea of what we're dealing with here in the situation. Once all of our evidence and arguments were docketed, somehow, somewhere, someone inside the system on our behalf tried to silence our case. So we don't know who it was. This is not about assigning blame, but that just shows you the
I believe it's a good end for this session, but it's impossible. It should be possible for you to find out who exactly, claimed they're working on your behalf. Do you think you will be able to find it?
We are going to try, but for strategy reasons, we don't want to anger judges because it's very likely a court staff member. We don't know for sure. We thought that trying to push for this answer prior to having a hearing might prejudice our case, right? So we are planning on investigating this after we have our decision from the courts.
And one more question I have. So secret VE memo, it's the key evidence which you will be talking about, I guess, in the next episode. But what VE stands for? Secret VE memo?
For business engineering.
Okay,
it is
so it's your acronym. It's you developed this acronym, yes.
Yeah, it's an internal acronym in Service Canada. It's the management department that issues policies that determine how the EI process works.
Okay, excellent.
And we do have examples on our website, Justice for EI Misconduct. Okay. You'll see the
so that's our first episode.